Okay, this is an interesting question, guys. We're going to call court into session. Okay, and I'm going to put this on my YouTube channel. Hello, YouTube. So this person is telling me that they're saying this. I'm the defendant in 2 civil cases from the same plaintiff. The plaintiff has sent me Rule 194 request for disclosures on both cases. In one case, they asked me to make specific disclosures and ask specific questions. In the other case, they just said, give me everything underneath Rule 194.2. So I have a few questions. If the plaintiff didn't ask for specific info but just asked for 194.2, do I just pick the relevant items and reply? If the plaintiff only asked for specific items, do I need to disclose only specific items? Can the plaintiff ask for Rule 194 disclosures as well, or is the plaintiff obligated to disclose 194.2 info without me asking because he asked me for disclosure? If I do have to disclose without asking, what's the deadline for the plaintiff to make the disclosure? Is it the date of my answer plus 30 days? Okay, let's start from the top. Guys, okay? First of all, there is normally not a reason for the same person to have 2 cases against you, so that's a problem, okay? When you are filing cases and we are in court, the court of law, we do something called judicial economy. It is very rare that a civil case, they can bring 2 separate cases against the same person. More than likely, it arises out of the same relationship, the same circumstances and events. If it's the same parties and different circumstances and events, then you should just file one case and list the different issues on the different things that has happened or occurred. I don't understand why it's 2 cases. One of those cases is probably going to need to be dismissed, or those cases need to be consolidated and put into one. Okay, that's the first thing. So the person clearly doesn't know what they're doing, or their attorney is not doing things properly, because it is very rare that there are going to be 2 cases. Now, sometimes there may be one case in the Justice of the Peace Court, and then there may be one case in the big court. That can occur. But normally what happens is, if that is going on with my clients, I get that small case dismissed, and I pull the shit from the small case and pop that shit in the other case. Why do I do that? I do that because you're not about to work the hell out of me, okay? And you're not about to work the hell out of my client. Do you see what this person is going through, guys? They're like, do I answer this? Do I answer that? They're sending me 2 sets of blah, blah, blah. And pretty much a lot of those answers are going to be the same because it's 2 separate cases. So the first thing that you always need to figure out is, why in the hell are there 2 cases against me if we got the same parties on both sides? Even if we got different parties on both sides, if you and me have the same issue on other things, or we have different issues, all of our shit should be in one court case. So you need to move to dismiss one of them cases. That's it. And she needs to amend and bring her claims against you all in one case. That is not, bifurcating issues is not allowed. So those cases are not even properly filed, if you ask me, based on what you tell me. Because the type of attorney that I am procedural first, I am substantive next. Meaning, I look at all the procedural loopholes to an issue before I even attack the facts. Because at the end of the day, I can get a case dismissed on straight procedure and rules, and I don't have to go to the facts. Does that make sense? So the first thing that you need to do is look at those cases, and you need to look at procedure. You probably need to hire an attorney, because they'll knock one of those out more than likely for you off the bat. Now, when we are looking at disclosures, now the law has changed. Cases that have been filed within the past year or so are subject to a new rule. There are certain things that you must disclose regardless, whether it's a custody case, a divorce, a civil matter, on any type of civil matter, whether it be a car wreck, a breach of contract, anything, fraud. There are certain things that the government has said you must disclose here in Texas. Period. On period. And if you don't disclose these things, they can sanction you if the other party asks the court to do that. The court can sanction you in different ways. They can charge you money. They can sanction you by knocking off some of your answers or responses, or they can kick your side of the case out, okay, because you're refusing to disclose information that is statutory or codified by law. So at the end of the day, sir, what you need to do is, first, you need to look at those cases. Second, whenever somebody asks you specific questions, only answer the specific questions that they asked you. So in the case that you have specific answers, only give those responses. On the next case where they ask for Rule 194 disclosures, disclose everything underneath the new law that is applicable. Everything. And so what you do is I would copy and paste all the questions and put your answers underneath. If it doesn't apply, you would just put non-applicable, but you're going to give a response to everything on the disclosures. Does that make sense? And the disclosures are due from the plaintiff first. 30 days after you have filed your answer in that case, they should be sending their documents to you. Once their documents hit to you, you have 30 days to respond with your disclosures. So they can request disclosures of you, but at the end of the day, it's automatic on both of those cases that the plaintiff discloses everything underneath 194 to you 30 days after you file your answer. Okay? Now, you seem pretty swift, and a lot of times we are smart people, but I don't suggest this case being done by you. It's just because it's 2 cases and they already started out fucked up. If the case is, again, you are not going to keep nickel and diming me. Meaning, if you got an issue with me, bitch, bring all your issues at the same time. Don't say I had an issue with you because of July the 3rd and file a case. Then come back in October the 2nd of the same year you did this. And then the next year you did this. Oh, hell no. Bring all your counts, all your shit in one case so we can battle this out at one time. And that is what you need to say with respect to these 2 cases. I don't care if it's for 2 different things, and I don't care if it's on 2 different it doesn't matter. All the problems that you have with them, you got to run that at the same time. Am I making sense? You run it at the same time. And everybody included in all those issues is going to be wrapped up in the lawsuit too. Does that make sense? So it's going to be players on both sides, but between you and that plaintiff, all of that shit need to be in one lawsuit. And that's just, and I don't think you know what to do to get that done. So you need to get a lawyer for that. But guys, pay very close attention, because some people just like to file lawsuits and shit, wrap you up and mess you up. And they'll just keep filing lawsuits on you, but they cannot do that. The law precludes them from doing that, if that makes any sense. Okay? The law precludes them from doing that. And all you need to do is raise that issue, and the court's going to dismiss that shit because they're like, hold up, you already in here for this? No. Or you already have another court hearing this? No. Then I can't hear this. And another issue that comes with different cases in the same people is the reason the court says that is not only for judicial economy, so that you can bring it all in at once, but also because at the end of the day, there may be defenses that you have that overlap, or there may be facts that overlap from one instance to the next instance. So those cases probably have overlapping facts or overlapping evidence. Okay? What happens is when you run facts and evidence that overlap and intertwine, you cannot have 2 judges hearing those cases. Does that make sense? Because one judge is going to make findings on certain things in one case, and it can't go against the findings made in another case. So for that reason, the cases have to be together as well. Does that make sense? So guys, make sure when people are filing lawsuits against you, that they're not filing multiple lawsuits and it's the same person filing multiple shit. Because they're not allowed to do that, and you need to get that shit kicked out so that you can wrap everything into one and you can streamline and focus on everything at one time. The court is going to err on your side with that, and they're going to kick those cases out. With respect to disclosures, y'all, it's court order stuff that you have to give the other side at the end of the day. Make sure that you do that. Now the law has changed and it is court ordered always. Court ordered. They can also send you different requests in the form of request for production, request for interrogatories, request for admissions, or ask you to be deposed. But those disclosures, they're automatic. All right? You guys have a fantastic day. Please subscribe to my channel as well. Like this video. Make sure you follow me here. Follow me on Instagram, she_ya_lawyer. TikTok, LegalQTee, just like it is here. I have all different stuff on all different channels, okay? So, follow me everywhere if you want to know all the law and you want to get answers to all the questions. Okay? Have a fantastic day. Court is going to stand in recess, and I will see you guys next time. Goodbye.